Supreme Court dismisses plea seeking law to ban screening for nursery school admissions in Delhi. The Supreme Court on October 13 dismissed the appeal challenging the Delhi High Court order, wherein the court refused to pass any appropriate writ pertaining to expedite the finalization of Delhi School Education Amendment Bill 2015, which prescribes for prohibition of screening procedure in the matter of admission of children at pre-primary level, pre-primary in schools. The bench comprising Justice Sanjay Kishan Kaul and Sudhanshu Dhulia stated, "Can there be a mandamus to introduce a law?" That is the problem, and that is the view High Court has taken. How can we say High Court is in error? Supreme Court cannot have a panacea for everything. The petitioner in the present case was social jurist, a civil rights group, and organization of lawyer and social activists. It had been argued in the petition that the bill banning screening procedure in nursery admissions in schools was prepared in the year 2015, and for the last 7 years without any justification and against public interest. The bill is hanging between central government and Delhi government and is not being passed yet. Further, it was stated that the delay in proceeding further acts contrary to the interest of children in the matter of admission to nursery, pre-primary and private school, and has resulted in arbitrary procedure being adopted by different schools in matters of admission of children at pre-primary level. The petitioner sought to rely on the provisions of the Right of Children to Free and Compulsory Education Act 2009 to contend that in order to implement the provisions of the Right to Education Act, it was felt necessary to do away with the screening procedure for admission of children to nursery and pre-primary classes. However, the Delhi High Court in its impugned judgment observed that after the bill had a passage through the House of Legislature of a state, it is presented to the governor, and it is for the governor to declare at that stage whether he gives assent or he withholds the assent or refers the bill to the president for assent. Courts cannot control or interfere in this procedure and cannot direct the governor or pass a writ to the governor to grant assent or desist from granting assent. It is not proper for a High Court, while exercising its jurisdiction under Article 226 of the Constitution of India, to direct a governor, who is a constitutional authority, to set a time frame in matters which come purely within the domain of the governor. In the considered opinion of this court, even though the bill has been passed by the House, it is always open to the governor to agree or to send the bill back to the House, and this court ought not to pass a writ of mandamus directing the governor to act by passing a writ. The High Court held. And now coming to courtroom exchange, which starts with, to begin with, the counsel appearing for the petitioner made submissions before the bench regarding the objective and importance of the bill. However, Justice Kaul stated, "Can there be a mandamus to introduce a law?" That is the problem, and that is the view High Court has taken. How can we say that High Court is in error? Supreme Court cannot have a panacea for everything, the bench asserted. At this, the counsel explained, "We are only praying that what is the status of the bill?" Justice Kaul replied, "There were many acts, for example, the Rent Control Act for 10 years, it was not implemented. This is not an administrative action, this is a legislative side." Now Justice Kaul inquired, when was the bill introduced? Counsel, 2015. It has been 8 years. Then Justice Kaul replied, 8 years, obviously they don't want this law to come into force. What is the doubt in it? The counsel tried persuading the bench, however the bench was not convinced and dismissed the plea. So the case is social jurist versus the government of NCT of Delhi. Thank you.